Good morning, agents. Welcome, everyone. I am Michael Lolke from Assured Abstract. Today, we have a great presentation on EB-5s and, by extension, some information on immigration and foreign buyers. So it'll be a great presentation. And let me backtrack for a second. I am a title insurance agent. I've been putting on these Zoom classes since the beginning of the pandemic so that I can meet the real estate agents on the calls, on the Zooms, and also introduce you to great professionals. So today we have a great professional, Marco, who is an EB-5 expert. EB-5, as everybody who's on this knows or will know, is a methodology where you can get green cards and ultimately American citizenship through real estate investments. And we are all real estate people on this call, so it's a great bit of information you should know, whether or not you have a particular foreign buyer in mind right now, but it should be in your real estate vocabulary and you should know about it. So, and again, I do this class so I can introduce you to great professionals and also meet the professionals that you use. So please introduce me to your real estate agents, mortgage people. I'm happy to get them on these calls. I'm also very happy to do the title insurance work. So please reach out to them and introduce them to me. I can also introduce you to great professionals, real estate attorneys, mortgage people. Last week, I connected a real estate agent with an engineer who, as a courtesy to me, gave her an opinion on an inspection report that was a little problematic for them. So I can do things like that. I'm happy to help you. So enough about me and Assured Abstract. So Marco, please take it away and tell us all about EB-5s and foreign investments.
Thank you, Michael. Good morning, everyone. I'm delighted to speak with you this morning. I would like to take this opportunity, first of all, thank Bound Real Estate and Michael Lalkin for inviting me to address you. This morning, I plan to give you an overview of what EB-5 is and how it could help your real estate clients obtain a green card and ultimately U.S. citizenship in order to live and work in the United States. Due to the limited time we have, we'll go through the presentation rather quickly. Please try to follow along by watching the slides and listening to the presentation. There's no need to take any notes as we plan to make the presentation available online. My name is Marco Isever. I'm the CEO and founder of America EB-5 Visa, a company dedicated to connect international investors who aim to immigrate to the United States while making a meaningful financial contribution, typically in the form of real estate investment, with EB-5 issuers, typically real estate developers, looking into EB-5 as an alternate funding method for their projects. While no investment comes with zero risk, our professionals carefully evaluate both the investment projects and the qualifications of prospective investors. By way of background, I've been in Wall Street for over 30 years. Before establishing America EB-5 Visa a few years ago, I ran the Global Financial Institutions Derivative Sales Desk of the Bank of New York Mellon, New York. I'm a graduate of the Wharton School of University of Pennsylvania. Without further delay, let us jump into the presentation. In this presentation, we'll cover 9 main topics that are listed in this slide. First, we will talk about what EB-5 is, just basic information. We will then touch upon the reason why EB-5 might be a better choice than other non-immigrant visas such as H-1B or E-2. We will then explain how a potential EB-5 investor could obtain the necessary funds for the required EB-5 investment amount. It's called source of funds. We will then briefly elaborate on the regulations that change the EB-5 landscape for the first time since its enactment and the current status of the program. We will then discuss some of the most important selection criteria to pick an EB-5 project. Many people wonder if the location of the EB-5 project matters in terms of the ultimate place they would like to be working and living in. We will then give an overview of the timeline for the whole EB-5 process from beginning until the end. When potential applicants hear about obtaining a green card, they are oftentimes alarmed regarding global income taxation of being a US citizen or green card holder. They wonder whether that means that they will have to pay tax twice, once in their home country and then again in the US. We will diffuse all of these concerns. We will then discuss the meaning of retrogression, how does it occur, which countries are subject to it now, and lastly, we'll discuss some of the hot topics and recent EB-5 news. So what's EB-5? Congress created the EB-5 program in 1990 in order to stimulate the US economy through job creation and capital investment by foreign investors. Initially, it was created as a direct investment vehicle whereby foreign nationals, that is the EB-5 investors, would invest $1 million in a project of their own, or if the project was were in a rural jurisdiction or in an area that experienced high unemployment, then the required investment would be half of that, $500,000, which is probably what you know. This kind of area is called target employment area, commonly known as TEA. In November 21, 2019, the amounts were increased to $900,000 for TEA and $1.8 million for non-TEA EB-5 projects. On June 22, 2021, just about a month ago, a lawsuit challenging these new EB-5 regulations was successful, as Magistrate Judge Jacqueline Corley of the U.S. District Court for the Northern District of California ruled that the regulations were not lawfully promulgated because the then acting Department of Homeland Security Secretary was not properly serving in his position. So we're back to $500,000 investment amount now, but the program lapsed on June 30th. We expect the program to open up again in September and stay open for at least a couple of weeks. Potential investors who could get ready now with their paperwork will most likely be able to lock in this historically low, reduced amount of $500,000. We'll talk more about this later on in our session. It's estimated that after 24 to 30 months, the investor could be eligible for permanent residency approved for himself, her spouse, and their children who were unmarried and under the age of 21 at the time of the initial application. There is no restriction as to how many unmarried children less than 21 years old of the principal EB-5 applicant could apply under one single EB-5 application. 10,000 immigrant visas are annually allocated for this program. There is a debate between the USCIS's interpretation of the law as to whether the law meant 10,000 visas or 10,000 investors annually. This difference in interpretation makes a huge difference in the actual number of visas that are awarded annually. The current practice, unfortunately, is 10,000 visas. Some of you might have clients who have children currently in US colleges. Some of you might have clients who are thinking of sending their children to US colleges. Why is EB-5 relevant to a foreign student in a US college? If they apply for the EB-5 during their junior year or before, they would have a good chance to secure a green card before graduation, paving their way to be able to apply for a well-paying position in their field of study and commensurate with their education. Upon graduation, many students who do not have green cards are often forced to return to their respective home countries before having a chance to get practical training and a job in their area of specialization. OPT, also known as optional practical training, is limited in terms of duration. Moreover, companies do not typically want to hire and train recent graduates only to see them leave after a year or two. Lastly, students who are desperate to get a job in order to utilize their OPT option often settle for jobs that are not commensurate with their academic experience and the area of expertise they are seeking to be trained in. Green card holders, however, can choose from among job offers they receive in their field in line with their career development goals, academic standing. That enables them to make decisions based on position, salary, and geographic location.
他那个8895被16-3楼在装修，那装修是买家买的装修呢，还是 super 装修呢？在卖呢？对于他给我发，他说你可以带我去看房吗？人家的房子卖不卖呢？
Okay, well, keep going, Marco.
Why is EB-5 a better choice than trying to obtain an H-1B or E-2 visa? Aside from a limited type of family-based immigration, EB-5 is by far the fastest option of getting US permanent resident status, since there is no quota backlogs with most countries. Each country can send 700 applications annually before retrogression. In other words, quota backlogs. Right now, we have quota backlog only with candidates who were born in mainland China. Your client does not need any particular company to sponsor them or give them a job offer for that matter. H-1B is subject to lottery once a year. Generally, there are 300,000 applicants a year for 60,000 to 85,000 spots. The low chance of approval feature of H-1B discourages prospective employers to extend offers in jobs commensurate with their education and experience. They opt to hire potentially a less qualified candidate who's authorized to work in the US. The EB-5 that leads to obtaining a green card provides freedom to study, work, and live in the United States without additional immigration requirements for the main applicant and his/her derivative applicants such as spouse, unmarried children under 21. It may also reduce in-state tuition for the children of the applicants. Last but not least, it provides one of the safest paths to US citizenship. Now, what about E2? There is a tremendous misconception that E2 visa is an alternative to EB-5. If your client comes from a treaty country, the E2 investor visa is a viable option for them. If they are not from a treaty country, then we can get them the citizenship of another country that is a treaty country, enabling them to obtain the E2 visa. There are certain features of E2 that might be attractive to some clients, such as the speed at which they can get it. But at the end of the day, it's a visa, not permanent residency. So how can an EB-5 investment be funded? What are the main methods to fund the required investment? EB-5 investments can be funded in one of three ways: clients' own funds, borrowed funds, or gifts. The most common way the student applicants fund their EB-5 investments is through gifts from parents. Parents could fund the gift through their own funds, such as earned income, borrowed funds, or inheritance, to name a few. The funds that are invested in EB-5 need to come from verifiable sources. The EB-5 regulations require investors to prove that the investment funds were obtained through lawful means. In other words, the investment funds must not have been obtained through criminal activity. Obviously, in practice, nobody is expecting the funds to be earned unlawfully, but if the funds were earned in cash with no receipts and no tax records, that could obviously become challenging to document. Recently, USCIS has even started asking evidence of inheritance funds to be earned by the deceased through lawful means. The evidence in that case, of course, does not have to be as onerous, but still the heir who inherited the funds needs to be able to show that the deceased had the wherewithal to be able to earn the funds now being used to fund the EB-5 investment. Most recently, on behalf of H. Zhang and M. Hagiwara, their attorney, Ira Kurzban, argued that not only loans should be admitted as permissible to the funds, to fund the EB-5 capital, but that the loans did not have to be collateralized. Up until this ruling, we have always recommended our clients that while they could borrow money from different sources by pledging their assets, such as real estate or marketable securities, unsecured loans were not permissible. This ruling will most likely be very beneficial for EB-5 investors with respect to their source of funds. Why? Because now they can fund EB-5 on an unsecured basis. So this question we get a lot. How does one pick a project to invest in? What are some of the key due diligence criteria one should be aware of? Here's a few criteria. What is the track record of the regional center? The track record of the developer? It's very important not to be a guinea pig in a first EB-5 project unless you are being compensated very handsomely for the risk you are taking and accepting. How about the I-526 denial guarantee letter? Is there one in place? What kind of a TA analysis can the regional center show you? Is the developer or some other deep pocket providing a building completion guarantee letter? Is there a senior loan from a reputable lender in place ahead of the EB-5? If there is, that means that some professional due diligence has already been performed in the transaction with positive results. If there is no such loan in place, it is possible that the project is so risky that no lender has accepted a senior position in it. EB-5 investments cannot be made as loans. They have to be made as equity. Therefore, the regional centers need to form a new commercial enterprise, commonly known as NCE, in which EB-5 investors typically have a preferred equity position. The NCE lends the funds it receives from the EB-5 investor to another special purpose company called the Job Creating Enterprise, commonly known as the JCE. The JCE holds a title to the property to be developed directly or indirectly through layers of subsidiaries it owns. It's important to know if this loan by the NCE to the JCE is guaranteed by the developer or some other deep pocket. In the event of default, after the senior loan ahead of the EB-5 investors on the waterfall is paid off, if the liquidation value of the property is not sufficient to redeem the EB-5 investors fully, this guarantee would be triggered. Most EB-5 projects do not carry this guarantee, but if a project does have it from a reputable developer or another deep pocket, that's worth a lot. Once the loan by NCE to JCE is repaid, what is the reinvestment policy of the regional center before the investor files for removal of conditions through filing of I-829 and is ready to receive their funds back? According to the US Policy Manual update from June 2017, investors are eligible to be repaid upon completion of their 2-year conditional residence period. We call that the sustainment period, without jeopardizing their immigration process. It's not required for the capital to remain at risk until permanent green card approval. What is the regional center's policy in this regard? Is it revised to reflect the new development? How about the capital stack? How much senior debt, how much EB-5, how much equity is funding the transaction? How does the waterfall work? Is EB-5 ahead of equity committed by the developer? Is all the required funding to build the project already in place, or raising the EB-5 debt a crucial part of the equation? Who conducted the economic analysis and concluded that there will be sufficient number of jobs to enable all EB-5 investors to obtain their permanent residency? A more complete list of due diligence questions could be obtained from our website, americaeb5visa.com. Now, does it matter where the project is in terms of where clients might want to live and work? Why or why not? Because the EB-5 program is a federally approved program, as long as the project, the location of the project is in US soil, the state it resides does not matter. The location of the project and where your clients ultimately would want to live should be decisions they make on a separate basis, picking best of both worlds. So for example, they could pick an EB-5 project they really like in New York City from a risk standpoint, but decide to live in Miami or Los Angeles. Or vice versa, they could pick a project in Miami, but decide to live in New York or Los Angeles. So let's look at the timeline now. Stage 1, standard eligibility test, such as filling out investor questionnaire, understanding the financial obligations, selection of an eligible EB-5 compliant project, selection of an experienced immigration attorney conversant in EB-5, and collecting the necessary documents to demonstrate source of funds. Submission of funds into escrow account of the regional center for the project, admission to the fund that sponsors the EB-5 project, and finally, filing of the I-526 application. This is stage 1. So stage 2, decision on the I-526 application. USCIS approves or denies. Today, this decision is taking 24 to 30 months, in some cases 36 or more months. Upon approval, submission of the other legal documents such as I-485 in the United States or DS-260 if you would be applying from abroad to get the conditional green card. Today, this decision is taking roughly 6 to 12 months, in some rare cases even longer. Pass a medical examination conducted by your USCIS approved civil surgeon, as well as biometric screening. Once the adjustment of status is filed, they can apply for an advanced parole travel through filing I-131 document and a work authorization through filing I-765 document. Once their I-765 is approved, that means that they can now have employment authorization and can work. These documents enable them to remain in the United States, travel and work while their adjustment of status application is pending. And a 2-year conditional green card is issued. So this is the end of stage 2. And finally, stage 3, 90 days prior to the end of the 2-year conditional green card period, the immigration attorney applies for the conditions in the green card to be removed through the filing form I-829. Recently, USCIS issued a decision that says, we covered this a little bit before, the sustainment period is the investor's 2 years of conditional permanent residence. USCIS reviews the investor's evidence to ensure sustainment of the investment for 2 years from the date the investor obtained conditional permanent residence. An investor does not need to maintain his or her investment beyond the sustainment period anymore. So technically, if you have a client, if you have a direct EB-5 investment at this point, you can start downsizing. You do not need to maintain 10 employees any longer when I-829 is pending. So global tax and residency requirement of the green card, another question that comes all the time. When more than 2 students are eligible to apply under one application, one or both of the parents need to be the principal applicant or investor. It is possible that some parents do not want to participate in EB-5 due to their fear or better yet ignorance about the global taxation of income. Students oftentimes ask if their parents will have to pay tax twice, once in the home country and another time in the United States. The answer is, of course, not. The tax treaty is meant to prevent double taxation, which happens when an individual pays full income tax in a foreign country and also pays full income tax in the United States for the same income. The treaty allows the taxpayer to get credit for the local taxes paid on foreign income. If there is still some tax due after that deduction, that is when additional taxes would need to be paid in the United States. Even if even this is uncomfortable for the parent, then either they could surrender their green card once the children have their green cards, or they could have each child apply on their own under a separate EB-5 application. How about residency requirements? As soon as they get the green card, does the investor need to move to the United States? The answer is again, no. The United States is looking for intent to immigrate rather than immediately immigrate as soon as the conditional green card is issued. The immigration authorities understand that would-be immigrants have businesses they need to wrap up, properties they need to liquidate, and a whole life that they need to transport from one country to the other. The main point is, while the conditional green card is valid, the investor should not be away from the US soil for more than 6 months continuously. At the minimum, in a given year, they should enter the US a couple of times. This is another worry most foreign investors have. What is retrogression? How does it occur? Which countries are subject to it now? USCIS allocates 10,000 visas each year. As long as applicants from the entire world do not exceed this number, there would be no retrogression. However, when the number of applicants in any given year exceed this total allocation, applicants from oversubscribing countries are subject to retrogression. In other words, visa retrogression occurs when more people apply for a visa in a particular category or country than visas available for that month. In simple terms, retrogression means that your funds could be redeployed or reinvested to a new project, subjecting you to a longer wait time for your green card approval. In the last few years, there has been an enormous number of applications from countries such as China, Vietnam, and India. To make room for applicants from other countries, USCIS makes applicants from countries that experience retrogression wait. As far as EB-5 is concerned, currently, only EB-5 candidates from mainland China are subject to retrogression. When we say from mainland China, we mean born in mainland China. Only candidates who are born in mainland China are subject to severe retrogression. Anybody else? No. So a couple of hot topics here. The most important one, I guess, that we mentioned in the beginning of the presentation, the Bering Regional Center versus Chad Wolf lawsuit. This lawsuit is the second one brought against the government. Plaintiff was questioning the validity of the November 2020 2019 changes adopted and implemented. The first lawsuit claimed that the new regulations would cause economic harm. In the second lawsuit, plaintiff argued that neither the then acting Department of Homeland Security secretary nor the then acting Secretary Chad Wolf had the proper authority to propose and then issue the regulations. Greenberg Trauig, the legal firm, represented the plaintiff. This case is of utmost importance for potential investors who have been on the sidelines waiting for the possibility of the required minimum investment amounts to be adjusted down. The effect of the ruling is that the previous regulations revert as controlling, and therefore the minimum investment amount is now back to $500,000 for target employment area investments. This is the good news, but the program lapsed on June 30, 2021. But this is not so bad news. Candidates can use this time, meaning from now until the program is reauthorized, to prepare their application by having their attorneys work on their source of funds. They can also pick a suitable project to invest in, and we can also, of course, help with the due diligence and selection of the project. The second hot topic is the one that we mentioned, that uncollateralized loans can be used as EB-5 capital. No longer do investors have to secure their loans to fund EB-5 investments. So a couple of house items. What's the best way to reach us? If you have follow-up questions after the presentation, we will open it up to Q&A, of course. Best way is either to email us at info@americaeb5visa.com, or you can reach us on the phone. Your clients can call, whatever, on the number that is listed there. Thanks very much. We would be much like to hear from you. Please do not hesitate to get in touch with us. You can please, I just wanted to leave a little time for questions. Please don't hesitate. Any question is fine. We will be more than happy to answer. Michael?
So thank you, Marco. A lot of information packed into a short period of time. So agents, please unmute yourselves if you want to ask questions or use the chat feature. And Marco, I guess a general question is, so how does this help a residential real estate attorney, or is there or a commercial agent?
So obviously, every client, every international client who is in search of real estate here, which I presume most of the listeners are, that's their client base. Mm-hmm. Are also thinking about, once they buy this, unless it's for pure investment purposes and they have no intent to immigrate to the United States, they are just stop sharing here. So, yeah. They need to figure out how to be able to come here and live here. And we all know with a tourist visa, with a temporary non-immigrant visa, you cannot really live in the United States for too long. You have to keep on going back and forth. So EB-5, as we mentioned during the presentation, is the easiest, for people who have the financial means, is the easiest way of getting the visa. One thing that I want to say here, I think it's appropriate, just to diffuse some potential misunderstanding. We are not saying, just like in other countries, like let's say Britain, UK, or Australia, Malta, so many other countries, you buy real estate once you buy real estate, it gives you the ability to be able to get a green card. That's not the case in the United States. In the United States, the operative word is creating jobs. So what they need to do is, if the only funds that they have to use is the real estate purchase funds, and just let's assume, New York City, they bought a condo or something like that for a couple of $1 million, they could easily get a mortgage against that, and then they can invest those funds in EB5. I hope that's clear. In other words, the EB5 investment and the real estate investment have to be bifurcated. So anybody who claims that they need to be together is really not saying the truth. And that's why, if you recall in the presentation, I said those are two decisions that should be made independently. So if the real estate agents, most of them obviously, and in New York City, real estate agents here are promoting certain real estate transaction, and then we're talking about projects all over the country, there is absolutely no conflict with that, because they can sell them their real estate because their clients want to live in New York City, but then they can invest in a project. We have tons of projects that we've done due diligence on, and the client should pick among those projects the one that they feel is most commensurate with their risk profile, and that it can be anywhere in the country, in U.S. soil. I hope I explained, I answered your question. I don't know.
Yeah, so thank you. So basically, you can invest, you buy a residential piece of real estate in this country, in the United States, then you take a loan on that and you invest in a EB5 transaction or entity, and then you get your green card through the second step, which is the EB5. So it's a two-step process. I had hoped agents to have a banker that could do foreign national loans on. He couldn't make it so, but reach out to me and I'll connect you with people who can make those kind of loans. So that's an important concept, Marco. So do we have any other questions in the agents?
Yes, this is John Biostra from Corcoran. And I have clients in this country from India already working here under HB1 visas, and I'm wondering if this program could help them. They were looking to invest in a New York condo just for investment purposes, and they've sort of cooled off on that idea to invest elsewhere possibly. But is this applicable to people who are already in the country and working on an HB1 visa?
John, I'm so happy that you asked this question, and I am so embarrassed that I didn't have that part of my presentation, but I really thank you for the question, because there is really one country in the world, and that is India, where what you just asked is the most relevant. And I'll tell you why. Because Indians from the H-1B, they were very easily going to the EB2 and EB3, employment-based green card path. Just like what we said in the presentation, there is a huge retrogression for mainland China-born applicants for EB5. A much worse retrogression exists for Indians on the EB2, EB3 category. So EB5 is really the only good choice that H-1B holder Indians in this country have. So the answer to your question is absolutely yes, and most Indians are already doing that. That's why when you look at the charts, India is the highest in terms of EB5 applications, and most of those applications, believe it or not, are of the type that you just mentioned. So they have great jobs. They are lawyers, they're IT people, they're doctors. I mean, Indians in this country, they have the best jobs, and they've been holding those jobs for 5, 7, 10 years, but they are approaching a very sad phenomenon, really. They're approaching to a point where they can no longer extend their H-1B. And guess what? If they cannot, they'll have to go back to their country for a few years at least. So if they have the financial means, and most of them do, because they've made US salaries, US income, so they obviously have the funds, and maybe not aware of this, this opportunity. So if you have clients that are in that category, they are definitely great candidates for this program.
So circling back to that briefly, they may not be aware, well, they probably are aware that their HB1s have a limited renewability. I know it's very inconvenient for one of the particular people in this party. He just left to one of the islands because he had to leave the country to get back in to get his HB1 renewed. So once they decide to enter this program, is that requirement still in place that they leave once a year until approved, or until there's a certain, I don't know, maturity in their investment, or once they enter the program, are they relieved of that necessity to leave the country for, I don't know how many days they have to leave before they come in and get it renewed?
Another very good question. So first of all, H-1B cannot be renewed indefinitely. It's not like E-2. If they, and for India, there is yet another problem with E-2, which I can briefly touch upon after answering your question. In the H-1B, there's a limited number of times they can renew it. And once that's expired, then they will need another visa to be able to stay here. So the short answer to your question is, unfortunately, filing a petition for EB-5 does not grant you ability to live in the United States. You need to be approved for the green card. And the green card, at least the conditional green card, the first green card, is a two-step process. The first process is to file the 526 petition. And once that is approved, then if they are in this country, they're just going to go to adjustment of status from their H-1B to the green card. If they were in India, they would go to a consular embassy interview. So I hope I answered that question. In other words, filing EB-5 is not a immediate solution. It's definitely a solution which comes, in a couple of years. On that note, I gave you some timelines, which might have been a little bit scary, too long. Recently, there's a new head of USCIS that was appointed, and she said that her biggest priority is to tackle these backlogs. She's going to try to figure a way to bring them back at least to the way they used to be, where you would be able to get a green card within 2 years. An Indian who is about to, whose H-1B renewals is about expiring, has a few options. They can always get some kind of an F1 visa, like a postgraduate or graduate study, just so that there is a visa here that they can stay, which will enable them to stay in the United States. Or we have also advised them to get a second country citizenship. So you have a couple of countries such as Grenada and Turkey, and we do help investors with that as well as an adjunct business, where within 6 months they can get the passport of Grenada or Turkey. And once they do that, once they get this second passport, India, which does not unfortunately have a treaty, India that does not have a treaty with the United States E2 treaty, now these Indians now can avail themselves to the E2. And with that, they can obviously stay here. Now, one thing about E2, which I don't think I mentioned in the presentation, which is a very, very interesting benefit, if the E2 visa is obtained by the spouse, whether sort of the other person, the one that is the spouse of the E2 holder can actually work anywhere he or she wants. So let's say that one is the breadwinner, the other one is the homemaker. The homemaker gets the E2, and the breadwinner, the one who has a higher potential of income being employed in or continue to be employed where they were employed with their H-1B, they can continue that as the spouse of an E-2. So all of these are solutions for let's say an Indian client who's applied for the EB-5 but is trying to find a way to stay in the United States legally, because you don't want to stay here illegally. Once you do that, then there are a whole host of problems that we can discuss.
Thank you very much.
My pleasure. Anybody else? Okay.
Okay, Marco, I know you put your, why don't you show the slide again with your contact information if people want to take it down so they can reach back out to you. And of course, agents, email me. I can happy to forward you Marco's information. And Marco, the plan is to send the presentation to any agent that registered?
Absolutely. I would more than happy. I mean, I have the PDF version of this that I can send you, and then you can forward it to all the registered people.
Okay, great. And
Okay.
also I'll include a contact for at least one banker that can do loans to foreign nationals. So that will be helpful to the agents. What last chance agents, we're getting to, well, we'll just close it out here. I think Marco actually has a tight meeting at 11 o'clock, so we'll let him go. Reach out to Marco if you have any additional questions. Reach out to me if I can connect you with attorneys who work with foreign nationals. Happy to do that, and happy to meet your attorneys that do work with foreign nationals and do the title insurance on your transactions. Also, feel free to reach out to me with any real estate questions. If I don't know the answer, I'll connect you with somebody who does. So Marco, any closing thoughts?
No, thank you for your participation. And as Michael said, we'd love to hear from you. Please don't hesitate to get in touch with me. Don't have to have a client immediate. We can discuss. There's obviously way more to speak about. This topic is a very wide topic, and there is a last chance really right now. I don't know how much that came out in the presentation. It was 500,000 until November of 2019, and then briefly for 18 months went up to 900,000, and then got knocked down by court in June. Really, very, very recently. The government is not very happy about that. They want to bring it back up, but they have to comply with what the law with what the court said. So for customers, this is really the last chance. Now it's in the hands of the Congress. Nobody thinks that the Congress is going to come up with a brand new law. They're just going to kick it back to the government to take care of it. So while the government is trying to do their best, to pump it up to 900 or whatever number, again, the clients have probably the last opportunity to be able to get in at the 500,000 level. We've already seen, I mean, when the court made that decision, and between the decision date, which was like the 20th of June or something, and then June 30 when it lapsed, those 10 days, we had a huge number of applications, skeleton applications, we call them, just got in. And now we have time in August, maybe a couple of weeks in September, to get ready for source of funds, picking up a project, picking up an immigration attorney, and then be able to apply at the 500,000 level. So reach us. Don't hesitate, and would love to hear from you.
Great. So thank you, Marco. Terrific presentation. So agents, think about the possibility that sending out in your newsletter or a specific email something about EB-5s, and it's a great way to connect to your clients and gets you in there and keep you top of mind so that they'll remember you as their real estate agent. And so we'll close it out with that. And agents, again, please introduce me to your real estate attorneys, if you need real estate attorneys, I'm happy to connect you. If you need mortgage people, the same for that, and any other related professionals. So again, I'm Michael Lolkin from A Short Abstract. Thank you for attending. We have a great presentation coming up on Thursday. It'll be about how to stand out from the crowd and how to tell interesting stories and get people to pay attention to you. So look for the invitation for that. And thank you all. Have a great day and enjoy the beautiful weather.